Hey friends, join me live tonight. We're going to talk about some really good news. Public charge has been blocked. If you're interested in hearing about what the next steps should be with respect to an RFE or a notice of intent to deny, watch this video. We're going to go through the rules together, and the government has finally done the right thing. Okay, so as you're coming on board, just give me some hearts and likes, and let me know where you're watching from. It's nice to see you guys. Thank you so much for being with me tonight. I see folks are joining. Now, yesterday, we did get some really good news that the Department of Justice has decided to give up its public charge fights. Under the Trump administration, the Justice Department was advancing an appeal. Okay, they were appealing lower court decisions around public charge, and they finally said, okay, this is the Biden administration now. We don't believe that we should have a wealth test that stands in the way of people getting their green card. And so we're going to give up this fight at the Supreme Court level. And so they have moved to dismiss their case at the Supreme Court level. And that is really, really, really huge, because the USCIS has decided to take immediate actions with respect to this announcement from yesterday. And so they issued their guidance today that's telling us what to do now. What should we do next with respect to public charge? So this is great news. Guys, great news is beginning to trickle in. I did tell you that it's going to trickle in little by little. Okay, just a few weeks ago, we were celebrating the fact that the family ban has been lifted. And now tonight, for those of you who really cared about public charge and this wealth test, we do have something really wonderful to celebrate as well. So I'm excited to see you guys and to have this discussion with you. Also, I had a video out several weeks ago that basically laid out several things that the Biden administration can be doing right now to make things better for immigrants and to show that they are really, they are all about change. And one of the things that I talked about is the fact that they could put public charge on hold until during this review time, because they are doing a review of the new public charge rules that went into effect last year. They're doing a review, but they could put public charge on hold during this review, and that's exactly what they've done. They've given up on this. And so we're expecting down the road, they're going to come out with some report of some sort based on the review that they're conducting right now of public charge. But what matters right now is the fact that we don't have to deal with Form I-944 anymore, the Declaration of Self-Sufficiency. And that is definitely something to celebrate. So let's get into it. So let's jump on USCIS's website to see what guidance they came out with today about how we should handle the changes that is now here. The day came, guys. Guys, listen, let me just say this. The day always comes. I don't know who that's for, but the day always comes. So keep that in mind. And so today we're talking about the fact that we don't have to deal with public charge anymore. Okay, so according to, and you guys can write that in, type that in, the day always comes. The day comes, guys. Okay, so here we go. According to the USCIS, and I know this is going to be a little hard to read, the text may be a little small, so just bear with me. I'm going to read it. But they basically said, in their opening paragraph here, they're reminding us about the judicial process that happened on the lower court level with respect to public charge, and the fact that the Northern District of Illinois had vacated the rule nationwide October 2nd, 2019. I'm sorry, hold on one second. On November 2nd, 2020, that's when the court had vacated the rules. And so basically they're now saying they basically agree with the lower court's decision. They're going to follow what the lower court has held. And here we go. We immediately stopped applying the public charge final rule to all pending applications and petitions that would have been subject to the rule. USCIS continues to apply the public charge inadmissibility statute, which is the old one, including consideration of the statutory minimum factors in the totality of circumstances in accordance with the 1999 interim field guidance, which was in place before the public charge rule. Final rule was implemented on February 24th, 2020. Let me jump down to, this is providing a little bit of legalese here, and I want to get down to the language that matters to you. It says this: on or after March 9th, 2021, applicants and petitioners should not provide information required solely by the public charge final rule. That means that applicants for adjustment of status should not provide the Form I-944 Declaration of Self-Sufficiency or any evidence or documentation required on the form with their Form I-485. And so they are effectively saying, guys, that they no longer require you to submit evidence proven that you can stand on your own 2 feet in America, okay? The factors that they were looking at around your age, your employment history, your household size, your income, assets, resources, education and skills, and health, right? They're saying they're taking that off. And all of the evidence that they had required around all of those factors, they're saying that they're not requiring any more evidence about that when folks are applying for adjustment of status. Applicants and petitioners, and also here, for those of you who are in some sort of non-immigrant stay, it says applicants and petitioners for extension of non-immigrant stay and change of non-immigrant status should not provide information related to the receipt of public benefits on the Form I-129, Form I-129CW, Form I-539, and Form I-539A. So those individuals do not need to prove anything related to public benefits that they had received as well. Then it says this: if an applicant or petitioner has already provided such information, okay, for those of us who did prepare cases and you guys prepared your case and you did provide information around public benefits or all of those factors, it says if an applicant or petitioner has already provided such information and USCIS adjudicates the application or petition on or after March 9th, 2021, we will not consider any information provided that relates solely to the public charge final rule, including, for example, information provided on the Form I-944, evidence or documentation submitted with Form I-944, and information on the receipt of public benefits on Form I-129, I-129CW, I-539, I-539A. So guys, one of the cool, and I'm going to dive into the next piece here as well. But before I do so, I just want to show you something really cool. So on USCIS's website, if you go to forms, right? Let's say we go up to forms and let's search for the Form I-944. Where is it? Is it there? Is it there? No items matched your criteria. They pulled it. They have pulled the Form I-944. So Declaration of Self-Sufficiency is no longer something that we really need to worry so much about. Now, let me try to get back to the press release here about this issue. So they have pulled that form. And now the question is, and I'm back. The question now is, what about if you had received, like, you know, some of we're working on some RFEs and some RFEs related to the I-944 Declaration of Self-Sufficiency, and some people had received a notice of intent to deny. What about that? What about the RFEs that's asking you to submit the I-944 and all related evidence to support the I-944? What do you do now? What should you do? Well, according to the instructions here, let me just back up. It says this: if you received an RFE, request for evidence, or a notice of intent to deny, requesting information that is solely required by the public charge final rule, including but not limited to Form I-944, and your response is due on or after March 9th, 2021, then you do not need to provide the information solely required by the public charge final rule. So they're saying that if your response is, you have a response due date that is after March 9th, yesterday, March 9th, 2021, then you do not need to submit the evidence that relates specifically to the Form I-944. However, if that RFE, if that request for evidence, or if that notice of intent to deny addresses other issues, if, for example, if this is a marriage case and it addresses the request that you receive from the government, ask you for more evidence related to the bona fides of your marriage, so to speak, right? They're asking you for more evidence or related to the marriage, or if they're asking you for evidence related to other issues, you've got to address those other issues. You still have to respond to that RFE. However, you do not need to respond to the part of the RFE or NOID that relates to the Form I-944. It says, however, you need to respond to the aspects of the RFE or NOID that otherwise pertain to the eligibility for the immigration benefit you are seeking. If USCIS requires additional information or evidence to make a public charge in admissibility determination under the old rules, under the old statute, consistent with the 1999 interim field guidance, they will send another RFE or NOID to you. So if they have any other concerns about, how dependent on government benefits you are, how dependent you are on government benefits, they're going to inquire into that, and they have a right to under the statute. Okay. So that's where they're at. And then let's see what else they say here. They say that we will issue additional guidance regarding the use of effective forms. Until then, USCIS will not reject any Form I-485 based on whether you had included or excluded the Form I-944. So they're not going to, if you apply for adjustment of status, the way I'm reading this, if you apply for adjustment of status, submit your Form I-485, and you did not include the I-944, they're not going to reject your application based on that. Okay, and they say they will also not reject the Form I-129, I-129CW, I-539, and I-539A based on whether the public benefits questions on those forms have been completed. So this is terrific news, and I kind of wanted to take you guys into that because it's terrific news. There's not a smarter way to say that. And then also, guys, this is the DHS statement. Let me just see if I could move myself here. So yesterday, the DHS did issue this statement in which it says that as part of the review that they're doing, DHS has determined that continuing to defend the final rule, the public charge rules, is neither in the public interest nor an efficient use of limited government resources. They're saying they don't have the resources to continue to pursue this, and that consistent with that decision, the Department of Justice will no longer pursue appellate review of judicial decisions invalidating or enjoining enforcement of the 2019 rule. And so that's that. Boom, just like that. Told you guys they could do it easily. They don't have to continue in that litigation. Why should they? They didn't have to. And so we're thankful that they did get rid of this. They have moved away from this awful wealth test that, there were times when I sat with some clients and it broke my heart because they didn't have the resources, the assets, the income, all of that. But should they have an opportunity to apply to get a green card? They're married to their spouse here in the US. They want to stay here. Of course, they should have that right. No one should deny them of that right because they don't have the income, assets, and resources. So I'm really glad to see that public charge, the harsh public charge rules have really been dealt with. So guys, that's great news. Share this video with other people. Thank you so much for joining me tonight in this live session. I need to keep it short for you. And the news came out yesterday, and I didn't want to come out and just break it to you like that. I wanted to wait until the USCIS issued the guidance so we would know what to do now. And so in my office, now that the guidance came out just tonight, actually, so now we know what to do with respect to the request for evidence, as well as the and any NOIDs, notice of intent to deny. But don't make the mistake, guys, of being so enthusiastic about this and then throw out the RFE or throw out your NOID thinking, oh, that's it. And then, oh my God, you may have you missed a paragraph in your the document that said, oh, also we need you to submit to us, another affidavit of support or something like that, something important, or we're missing this, your I-944, your entry record, something. Don't overlook anything else that they have requested from you. Promptly gather those evidence together and respond with respect to those other things that they've asked from you, especially if they sent you a notice of intent to deny. I'm pretty sure they may have addressed other issues. So you really have to take that very, very seriously. Guys, if you need help with your immigration matter, reach us on our website, book a consultation through our website. We are a little busy right now. We have entered into our busy season, but you could still get your meeting with us so that we could start on your case. And I have another video. I did a video for you guys just a few days ago, actually, in which I broke down in a presentation format one of the success stories that we have recently around adjustment of status. And I broke down my 3 strategies for how we do it. My framework, I basically gave you my framework in this video. And in that video, it does talk about public charge. I'm still going to put out the video because I did it before public charge was blocked. Because I'm going to still put it out there to you because there's a lot of things in there that you could learn from. So just know that the public charge portion of that video is not that relevant anymore, but the rest of the video is relevant. And I may just, do a little disclaimer in the video to let you guys know that public charge is not something you need to really be worried about. But the other information, 90% of the video is not about public charge, and you can benefit from it. So be on the lookout for that video. It's one of my winning tips videos, chock full of information for you guys. Guys, thanks so much for watching. If you're watching this on the replay, subscribe to my channel, McBean Immigration TV. Hit the notification bell. And guys, thanks so much for being with me tonight. And I will see you in the next one. Bye-bye.